This is Eitan Weinstein.
And I'm Naor Menninger, and you're listening to Two Nice Jewish Boys.
Today we will be diving, yet again, into the current political turmoil in Israel, sparked by the proposed judicial reforms by the new Netanyahu government. For those who have been living on a different planet, under a rock on a different planet, massive demonstrations and an immense campaign throughout mainstream media against the reforms have led to a complete backlash, tearing apart Israeli society. The place where these reforms are being prepared is the Israeli parliament, the Knesset, and more specifically, the Law and Constitution Committee, led by MK Simcha Rotman, who was actually a guest of ours on episode 275, so if you want, check it out. Today, we have the privilege of speaking with one of the advisors for the head of the committee, Professor Talia Einhorn, who just arrived from Jerusalem and even today took part in the committee. Professor Einhorn is an accomplished law professor with countless articles and studies on important topics revolving around Israeli and international law, including a major treatise on Israeli private international law, the third edition of which was just released in 2022. She is a titular member of the International Academy of Comparative Law and has been serving as a member of the Advisory Committee for the appointment of senior civil service officials. Join us as we discuss the current state of affairs in Israel and gain insight into the proposed judicial reforms from an expert in the field. Thank you so much for joining us.
Thank you so much for having me.
So where should we start?
You're not only an expert in the field, you're actually there, seeing how the sausages are being prepared, being made in the factory.
This is the fifth week that I've been taking part in every session from Sunday till Wednesday, sometimes coming back home at 11:30 o'clock, at 23:30 midnight, almost, wow. Or 9:30 at night. Yeah, but
it's complete chaos. I think if an American, would see those sessions, they'd be, they'd jump from a tower or something.
I think the most dramatic the American the chambers of politics in America get is probably like filibustering. Like if they read like a Dr. Seuss book.
the new version, the 2022 version.
Well, it goes like this. Some parts of the sessions are really, as you have just described. And then the photographers jump in and just take videos of these parts. But much of the time is spent really in, at least experts come from both sides and speak very seriously. What we have is an opposition that is not even trying to make any suggestions. All they want is to have chaos, to disrupt the sessions.
Opposition parties or opposition in general?
No, the opposition parties. The parties, especially Yesh Atid, led by Yair Lapid. His party, the members, they come simply to
disrupt.
But that's what the Likud did also in the previous,
But
that's what opposition does.
Yes and no, because, for instance, when there was need to reform or introduce amendments to the citizenship law statute, the Likud and the Religious Zionist Party and all parties, in fact, the opposition parties joined with most of the coalition to introduce the very vital amendments.
Because they agreed on the agenda.
Yeah,
they didn't agree, they...
However, I'll give you a simple example. Speaking, let's say, of the Labor Party. Professor Shimon Shitrit, who is leading constitutional law professor. He was also a minister of justice and so on. And he published in 2021 a book proposing reforms that are more far-reaching than those of Yariv Levin. Today, Oded Forer of Israel Beiteinu party came to the Knesset, and he too had suggested reforms that were more far...
In the past.
But what do you mean the past? A year ago?
A year ago, yes. Now he's opposing. Now he's opposing the reforms, and then Simcha Rotman, the head of the committee, told him...
he said...
Yeah,
I'll be happy to take the package of your reforms and forget about mine.
Yeah.
And what about that? No, the times have changed. But the same happened with Professor Shimon Shitrit. I was interviewed together with him on the Knesset channel. They asked me 2 hours ahead if it was okay to interview us together. I said, surely. And then we're introduced, and Yanil Kozin, the journalist, says, well... you come from both sides of opposing sides regarding this reform. What have you got to say? He turns to me and I say, well, I love reading. It's a Zoom thing, so you see behind my back of my library, part of my library. Yeah, that's very visible. And they say, well, I'm holding in my hands a book published in 2021. A very fine book on Israeli law. The author is published by a very fine publisher, the Greutel. And highly, I recommend to everybody to read this book. The author is Professor Shimon Shitrit. And on page 229, he goes much further than Yariv Levin. And Yanil Kozin looks at Professor Shitrit and says, can it be true what she is telling us now?
You too, Brutus?
And the answer is quite amazing. Yes, of course. Of course it's true. I read out what's written there. No judicial review of statutes at all. Okay, so, but that...
What was his answer?
The times have changed.
The times have changed.
Yes.
Quote verbatim, that's what he said.
Yeah.
From a year ago.
The
only thing that's changed is that he lost that camp lost at the elections.
He said, this is the proposal I would make in normal times. But these times are not normal. And then he came to the Knesset committee, and I was sitting there, and once again he said, yes, I'm aware that I have made different proposals, but these were for normal times. Now, for the life of me, and Gidon Sar, and other parties, they all signed. They submitted such bills to the Knesset, endorsing a very strong reform, and now it's all. And this is incredible. I find this. What can I say? This is all taking a position. It's not serious.
Yeah, it's pretty crazy. But I have a question.
In fact, Lapid himself said some months ago, he said that it cannot be that the Bagatz, the High Court, the Supreme Court, sitting as a High Court of Justice, takes decisions on matters of politics and economics and so on. I mean, and now, his party is really.
It's the position. It's the position. But there is no one in the committee that brings forth legitimate objection. Maybe not politicians that are part of the opposition, but maybe academics or people who are coming from NGOs or lobbies or whatever.
Yes, they're bringing all kinds of oppositions, and that's true. And that's the more interesting part of the debate.
So what do you feel is the number one objection in your mind that actually does trouble you? Meaning, from someone who does, because I want to try and challenge a little bit. Anyway, I want to ask you kind of what is the number one objection that has been brought to the committee that you've heard that is actually a valid criticism of the reform?
You're asking too much. Because the objections are not valid, but I can tell you what they sense as the most contentious bone in this. That's the appointment of the justices. I mean, those Now, this needs a bit of an explanation. What is the situation now? What the reform seeks to achieve? And
let's dive in. What's the situation now?
The situation now is that the appointments committee, there is an appointments committee composed of 3 justices, the president of the Supreme Court and 2 justices of the Supreme Court, meaning 3 justices altogether, 2 members of the Bar Association, 2 ministers from the government, and 2 members of Knesset, usually one from, but not necessarily, one from the coalition, one from the opposition. Now, where's the problem here? The problem starts, the 3 justices vote unanimously. So even though it's not allowed by the law, each one has to take his own decision, but in practice, they vote like you could have had just one justice there. The members of the bar
they have interests.
Almost always go along with the justices. So you already have 5 out of 9. Now, assume that the coalition is a right-wing coalition. So they have 2 ministers and 1 member of Knesset. That's 3. The opposition will go ahead with usually with 5 that anyway have a majority. So now... And
you need a 7.
Now wait, for the Supreme Court, you even need a 7 votes in favor. Now,
but
if
for the
it's
other courts, no.
No, for the other courts it's a simple majority, but the simple majority is there anyway.
Yeah.
Now, to get 7, this means essentially, first of all, that the Supreme Court has a veto over who gets in, because you cannot do it without them. And secondly, that there may be a little bit of an influence if this is a right-wing coalition. If it's a left-wing coalition, as we had in the past year and a half, then it's 8 against 1. And then, let's say, we know it. This is exactly what happened. They appointed 61 judges in less than 5 hours. They just have it all. Now, this is not a normal situation. Now,
but the judge, Aaron Barak, if he would sit here, would tell you, excuse me, we don't. Why do you put left and right to us? We're not left and we're not right. We just do what's best for.
We're judges. We're blindfolded and we're only influenced by the scales of justice.
They're with the left.
Yes. Well, the fact is that if you look at the record of decisions of the Supreme Court sitting as a High Court of Justice, and I would like to say a word about this whole institution of the High Court of Justice. But if you look at their decisions, oddly enough, you get 10 out of 11 or 6 out of 7 or 4 out of 5 who vote in one direction. And you can guess already by the composition of the panel how the result will go. I mean, and this is clear. I'll give you some examples. But maybe even beforehand, I should explain one thing about this situation, this institution called the High Court of Justice. It's the Supreme Court sitting as a High Court of Justice as a first and last instance. This is something of which there is no comparable court in the Western world. You always, before you get to the Supreme Court, you have a trial court that finds out, does the fact-finding and has evidence. In common law countries, there is a clear cross-examination and so on. So, in other countries, the judge will ask questions and also the lawyers prepare. There is a trial court that gets the facts correctly. And then on appeal, try to get to the American Supreme Court. Yeah, you go first through the trial court or the district court, and you have the appellate court. In the States, you have also a Supreme Court. And then finally, at the last stage, you get to the U.S. Supreme Court. Or in England, you go first to the High Court of Justice, then the appellate court, Court of Appeal, then the Supreme Court.
You're talking about what's called the right of standing.
No. I'm talking about
appealing up the ladder.
Appealing, okay.
Wait, I'll get to the. Of course, I'll get also to the standing. But how do you get it all to the Supreme Court? In states where you have a constitutional court, you don't go directly to the constitutional court. You first go to one of the, it may be the civil court, or it may be a criminal case, or it may be an administrative case, or a matter of tax law. So there are different courts. They will hear the case, and if there is a constitutional question relating that arises out of these facts, this case, then that question will be put to the Constitutional Court. This is the largest bulk of issues with which the Constitutional Court is engaged.
The Constitutional Court in the United States being
No,
state?
in Germany, in the United States there is no. But
Okay.
if you look at Germany, for instance, Germany has a Constitutional Court, and you don't just come to the Constitutional Court, say, hi, I'm there. Now,
Take a number.
Now, just to give you an idea what happens when you don't have fact-finding, so we had the people of Ammona. Ammona is a settlement in Judea and Samaria situated in a strategic place, was a settlement, I should say, and came along Arabs to the court and said, well, we're the owners of this land and the people of Ammona should be evacuated. And the court heard, looked at the affidavit, and said, yes, this must be private property, and made an order that Ammona should be destroyed as a settlement. Then the same petitioners who came to the High Court of Justice went to the district court and said, now we want compensation for the whole time that Ammona was situated there. The state woke up and said, why don't you let's see that you prove your ownership. And it turned out that only a tiny, tiny fraction, 2 dunam, which is nothing almost,
2,000 square meters.
Belonged to
2,000
this.
square
Yeah,
meters?
yes. Belonged to these people, belonged to these persons. That's all. So, there is no, or if you want, you can take the gas plan, the exploration of gas. Noble Energy was the explorer, and the state changed the rules of the game several times, and finally they said, okay, for the next 10 years we give you a stability clause. We're not going to change the rules of the game any longer. Comes the clinic of a law college, and this I'll soon give these explain how this can be at all, to the Supreme Court, and says, with affidavits, of course, that such a scheme, a stability clause, fits developing countries, but not developed countries. And there are 3 states that banned, developed states that banned stability clauses. England, very respectable, New Brunswick in Canada, and Alaska in the United States. And the court says, well, the stability clause cannot stand. Now, the only thing they weren't aware of was that these 3 states abolished these laws well before the court gave its decision. And the simple reason was that, let's say in New Brunswick, people were promised that instead of every investor who will not come, there will be 50 queuing to explore even without a stability clause. And guess what happened?
Nobody came.
Nobody came. And since nobody came, they repealed these laws because it doesn't work that way. In fact, the stability clauses are given between 10 and 25 years. So 10 years was really the minimum.
Now what you're talking about is the professionalism of the judges.
No, it's the system. It's not only the professionalism. Suppose I was sitting there. Now, what would I do? There is no system of fact-finding in the Supreme Court. It's an appellate court. It's not the normal thing. You have
So why
you
do
get
they
an
make
affidavit.
decisions?
What do you mean there's no... Isn't the system of fact-finding just question asking? Saying, show me evidence?
But there is no such arrangement. You just get the affidavits, and that's it.
There's no cross-examination?
No cross-examination. You see, I was a practicing lawyer before I became an academic.
There's
I had
no
been
cross-examination?
for 6 years, and then 5 years I worked for an industry. But in those 6 years, I also brought petitions to the High Court of Justice, and I had very tough time proving my case, because there is no way to put the person who gave the affidavit on behalf of the state, on behalf of the authority on the witness stand, and ask him to prove what he wrote in his affidavit. The affidavit can be detached from reality completely. And then,
we're talking about the Supreme Court
sitting as yes, but the proceedings are wrong. I mean, in other countries, you always have a trial court. And in Israel, we have already the administrative courts. And instead of taking all these proceedings and putting them in the district court, and the district court has fact-finding, you can ask questions and so on. It should be strengthened. The rules aren't good enough, the procedure rules, but there is something there, and at least the judges are more used to asking questions, which is not the case at all in the Supreme Court.
I mean, I'm assuming in the U.S., the process and the system is similar. It's just that you have this, they're not the court of first and last instance, meaning the lower courts are doing the fact-finding, and then it's assumed that if you reach the Supreme Court, you've gone through enough fact-finding process, and now we can look at the facts and make an educated decision on what's right or wrong.
No, there is still a question of law, and the question of law, but you cannot make a decision,
if you don't know the
legal
facts.
decision, if you don't know the facts.
But I can appeal to the Supreme Court.
Of course.
Anyone can.
That's standing.
Now, wait. Now, several things. There is, to make it even strong, to make it stronger, Justice Barak already started this, because when I was a practicing lawyer, the person who petitioned the court had to be directly affected by an act of the agency, the government, the Knesset. You had to be directly affected. You couldn't come on as a public, what we call a public petitioner, on behalf of
to be a side in the
public
argument.
at all. You have to be, yes, you have to have
To show damages.
or maybe you're afraid that there will be damages. You want to stop something ahead of time, but nonetheless you are directly affected, not somebody who comes on more or less on behalf of himself, but pretends to act on behalf, to petition on behalf of the public. So one thing, Aaron Barak said, he opened the floodgates to he dropped all this thing about standing. And you get most of the petitions brought to the High Court of Justice are brought by public petitioners, especially, I must admit, from one side of the political map. They're very welcome. Those who attack what the right-wing government does. Because let's say if you had complaints about the new when they made a terrible reform of the civil procedure rules, that was thrown out of court very quickly. But if you come from the right, meaning the left side of the political map, and you attack the exploration of gas, or you attack the settlements, or you immigration laws, citizenship,
nation-state bill.
Yes, well, Israel, the state of the Jewish people. So these, or you're trying to make some arrangements for the settlements, then these petitions are most welcome to the court, and the court picks them. And let's say now the most... how shall I say it? The most surprising was the decision of a Supreme Court justice that a public petitioner came in with the idea, the movement for quality of governance, that the court should make an order that Prime Minister Netanyahu is incompetent henceforth to run the government.
Yeah.
So the justice ordered the government to respond to the petition. I mean, instead of saying, hey, we don't have jurisdiction to deal with such questions. So the other thing, apart from standing, was that everything is justiciable. And so the Supreme Court decides matters of abolished tax law,
immigration law.
Immigration laws, definitely. I mean, with the result that infiltrators are filling the streets of South Tel Aviv.
And of course, who can be a minister?
And who can be a minister, even though, according to the law, Mr. Deri can be a minister. And by the way, even here, there was a big error on the fact-finding by 5 of the justices who said that he was stopped from running, but that was completely incorrect, factually, because Mr. Deri never suggested that he would take leave of political life altogether. He just, and I read the plea bargain, I read the protocol, the minutes of the court session and by the way, this was really a case that wasn't worth much. I checked that too. But in any case, I mean,
the prosecution wasn't worth much?
The prosecution wasn't worth anything. I mean, it was a shame.
So why did he settle?
Because 97% of people indicted in Israel end up guilty as charged. And
97%.
97%.
Which is like a flip from most countries, right?
And this may last for years and years. And already in his case, they were looking for something for 6 years. They were looking for big things like bribery and so on. When they finally didn't find anything, they ended up with something that was defined by the Attorney General for good reason, that it was less than a tiny mouse. It was not even a tiny mouse what they found eventually. I mean, it was
his brother who
Now, he didn't even owe 1 shekel to the tax authorities. Nobody claimed that. I mean, it was a question of whether he should have reported that a certain deal went to his brother and not to himself, or the value that his brother would have paid a little bit more purchase tax, but he didn't owe anything on betterment tax. So, in any case, there was nothing there. But the court nonetheless said, 5 justices decided that he had promised that he would never return to the political life. He is leaving them. Now, the interesting thing is that in President Chayut's decision, it is written clearly that the day after the court decision in the magistrate court, he went to his party and said, well, I'm going to lead you now, and I'll be your leader, and hopefully in the elections we will win. So this movement for quality of governance came immediately to the state attorney's office, and they said, hey, you should cancel the plea bargain. And at real time, and this is written in President Chayut's judgment, real time, the answer was, this was never part of the plea bargain.
Wow.
So
we gotta
that's incredible.
Let's get back to that.
I want to ask something. Hold on. I want to ask about because we've talked about the judicial reforms quite extensively, and I want to ask you personally, with the current state of the reforms, do you have any criticism of the reform itself? Do you have anything that you wish?
I would have gone further.
But okay, so
I'll explain why also, because maybe.
But is there anything you would pull back on?
Well, I'll explain maybe.
No, I'm saying, is there anything that you actually believe is taking a step? I'm sure there are places, we can think that certain things should go further and certain things should be held back.
There is one thing that comes up also from the complaints of the opposition, except that they're taking it in one direction, I would take it in another. That there is agreement within the Knesset committee, indeed, that the basic laws, the Israeli basic laws, are not really a constitution. I mean, they were voted by very few. Let's say the human dignity and freedom, liberty, human dignity and liberty was voted by 32 to 26
But later
members.
it was confirmed by
No,
some
never.
67 or 75 to 0, no?
Not really. And the fact is that
How come?
when the members of Knesset, they were promised by the chair at the time, who now says this is incorrect, but the words are in the minutes. There is no question about that. That don't worry, the court will not substitute with we are not making the court responsible for judicial review of statutes. This isn't going to happen. And the only member who didn't believe it was Michael Eitan from the Likud. He said, I'm worried about it. But he was the only one. They said, no, don't worry. There is nothing to worry about.
This is in the early 90s?
Yes, that was in 92.
But later I understood that it was passed with 65 and then 75 to 0. Is that not true?
The law itself, the basic laws, there is only, let's say, the basic law, Israel, the state of the Jewish people, that really got a very fine majority in all parts of the legislation, because you should have such a vote on at each step of the legislation. There are 3 readings. You should have such a majority, a full majority, an absolute majority in all readings. And this never happened with human dignity and liberty. Quite the contrary, when they came, now you're right, at one point they tried to restrict the law by setting an override clause or limitation clause, I would call it, that the law that you may make certain legislation that will be incompatible for a period of time and so on, but that has to fulfill like an override clause, and that got a certain majority, but that's not the whole law. So you have a problem here. Now, it's agreed, really. Also, the Supreme Court has proved that it doesn't care much about the basic laws, because it had already stated that it has the power to pass judicial review of the over the basic laws themselves. Mm-hmm. And they call it the doctrine of abuse of the constitutional power of the Knesset.
Like the unconstitutionality of the law.
Exactly, the unconstitutionality of the amendment, or the abuse of the power of the Knesset as a constitutional entity trying to make it. Something like that.
A non-constitutional constitution. Yeah, it's such a mind pretzel.
So now you can take it in 2 directions. You can say, okay, if we are agreed that this isn't a constitution, then there is nothing to hinge upon, to use as a hinge in order to pass judicial review. And indeed, when I looked at the cases of the Supreme Court, and I wondered, how did the Supreme Court decide that laws were invalid? How did they invalidate them? And when you read the decisions, it's an eye-opener, because what the court says is, well, yeah, Israel is the regime in Israel is a substantive democracy, and which means that it abides by universal values as perceived by the enlightened public.
Who said this?
This is written in one case after another when they revoke it started, of course, with Aaron Barak, but later on, this became, as Justice Fogelman said, by now this is mainstream that we can do this.
Universal laws as they are perceived by the enlightened
values.
Universal values as they are perceived by the enlightened public.
Yes.
That's how it's written.
Yes.
What?
Yeah.
Who are the what? Who's the enlightened public?
Yeah.
Who's the enlightened public? Does he define that? Does he define who the enlightened public is?
I think we all know who the enlightened public is. That's the 10 out of 11. Yes,
that's really written in judicial
This is
decision?
really written. I've just I've just submitted an article with these quotations.
We decided before the episode that we were going to challenge you, but you're making it very difficult.
So now
easy.
So now you can say, well, if this is the case, then there is no ground, there is no basis for judicial review of statutes. And indeed, England, that doesn't have a constitution, there is no judicial review of statutes. The furthest they went is with, as regards the European Convention of Human Rights, they made the Human Rights Act in England, which states that the court may declare a law, usually a provision of a law, sometimes it boils down to a word, that is incompatible with the Human Rights Act or the convention, essentially.
So what's the checks and balances in the UK for the government?
I really wait. I'll just give you another example. In the Netherlands, they have a constitution. And Article 120 states that there is no judicial review of statutes, of parliamentary statutes, and voila, red-headed people
aren't executed,
and nothing. In fact. Well,
maybe there's not enough redheads in the Netherlands.
The fact is that the systems work also in Israel. Was Israel not a democracy before the constitutional revolution? We were, and things even worked better, and there was more protection of basic rights of the individual than there is now. At present, in fact, there are two places where we have serious problems. One is, as I pointed out, basic rights are not properly protected by the Supreme Court because, look at, if you want, that's a glaring example what's happening in Netanyahu's case. I mean, one day after another, we find out that for no good reason at all, and without getting anything at all, people around Netanyahu, 1, 2, 3, 4, 5, their telephones were infected with spyware, and
by the police.
By the police, with the state attorney's office. The attorney general told the court at the time, gave an affidavit that he was following every step. Now he says that he wasn't aware of these things. By the way, even the main investigator said that he never signed anything, and now it came out that some of the orders, he was the person who signed the requests to have the spyware. Anyway, what's coming out, and in fact, the courts have sanctioned not only in this case, but also in this case, which brought about a loss of a change of the government. And finally we're back at that. But the problem is that these things are sanctioned by the courts. They allow trespassing of private persons and normal citizens to go ahead. And this is very problematic. That's one thing. They don't protect the minorities like the people of South Tel Aviv. They don't allow, today I read out in the Knesset, just as an example, terrorists. How do you punish terrorists? So the state wanted to
demolish their homes.
Let's take the denationalization.
Okay.
To remove they shouldn't be nationals of the, and this is even allowed by the 1961 convention, of which Israel is not a party. But nonetheless, this is allowed. And then the court said, well, you may denationalize him, but he must get permanent residency with all social benefits. And the court writes that in his favor, this person who blew up 24 people on a bus, he first was on a more crowded bus, and he left the more crowded bus and moved to the other one where he just had these 24 unlucky people.
That was probably obviously a part of his decision.
This stands to his benefit.
He was thinking about that.
So what kind of a protection is this for the people of Israel? There is no proper, and on top of everything, there is the question of the Jewish state. Israel was created as the state of the Jewish people. And I'm much more concerned that the Supreme Court will try to change this and turn Israel, because just a month ago, they also sent the Knesset, more or less, to amend the citizenship law in a way that will enable not only Jews, but also Arabs to reunite with family members from Gaza and Judea and Samaria, or the West Bank.
Like that was the situation for decades.
No, you couldn't...
Gaza women got married and got
yes,
for
but that
decades it happened.
It happened, but this isn't the law. And the law should be the other way around, and the law should be enforced. Also, you're right, Bedouins may have 4 wives, and some of them come from because they're cheaper. But this has to be taken care of, and definitely not to be encouraged instead.
But wait, let's make we gotta make life a bit hard on you. So, but maybe the argument would be that, okay, the UK and the Netherlands, they don't have those, they don't allow judges to overcome a decision of the government. But the UK...
No, not the government. We're talking about the parliament.
The parliament. But the UK and the Netherlands are not this country. This country is a country with a lot of anomalies, and thus it cannot be compared to other first world countries. For example, those countries are not ruling a military rule on territories and millions of people, okay, which we do, for example, right?
First of all, these people, by the way, are not most
citizens.
of them are subject to the
Jordan.
It's Jordanian law to an extent, but it's the Palestinian Authority. The majority of Arabs living in Judea and Samaria are subject to the Palestinian Authority, where human rights aren't respected at all.
Okay,
but this isn't Israel. This isn't, because in all civil matters, they are subject to their own. And in Gaza, it's the Hamas. It's a terrorist group.
Why would that make a difference?
Yeah.
Hey, you should help me.
No, I'm asking. I'm trying to strengthen. I'm setting you up. I'm lobbing you.
Doesn't feel like it. Why would it matter? It should matter. It's an example. There are many other examples. For example, Israel is the only country where 50% of the population doesn't work and doesn't pay taxes, or where half of the population isn't going to the military and half of the population is obligatory to go to the military. So those are all kinds of anomalies, and there are more anomalies, right? Where
okay.
You know what I'm saying? So maybe you do need someone who's objective. Maybe you need a dictatorship, is what I'm saying, basically.
No, what I would say is the following.
Very challenging.
This is
challenging.
great. No, thank you very much. I think this was a great point. I'll tell you why, in my opinion. You see, when you have a legislature, the Knesset, the government, and the court, each one has its rules, its role in society. Mm-hmm. The role of the Knesset is to adopt laws, and you're right, in view of the special problems of the State of Israel, we have parliamentary democracy, meaning that every coalition is composed of many parties, and they try to come to some kind of compromises, because indeed passing laws, adopting laws in Israel isn't easy. You have to go through, and getting 61 persons to vote on anything is the other way around. Now, the role of the court is to settle disputes in a peaceful manner under law. And the Israeli Supreme Court, what it is doing when it is trying to enforce its universal values, it creates more disputes than it solves. Because let's take, for example, the draft law. That would be, they said, indeed, there is a problem. You have a group of the population. It may be true that the army cannot really do anything with them because of their style of life, which doesn't really fit any army camp. But anyway, the fact is that the draft from them is coming in smaller numbers. So the Knesset worked very, very hard to find a compromise where a certain percentage will come in and to help also the others get into the workforce. The Supreme Court, just like that, abolished that law, saying this doesn't fit our perception of equality. Everybody has to be equal no matter what, and sent the Knesset to fix this in 1 year. Now, of course, this was unrealistic, and this was the trigger for 4 rounds of elections. And this shouldn't happen.
But
yes.
To give a counter-argument.
And was any Orthodox person mobilized to the army because of that? Nothing happened until now.
But if we take this example,
yeah.
And this is an example in which I am being, I can do anything against the fact that the Knesset wants to, I don't know how to put it even, wants to give them that privilege, which is, we can all agree, I think, that it hurts equality in the state of Israel, right? It's not equal.
I'll tell you what.
If I am forced to go to be a slave for 3 years, and another guy in Bnei Brak is he can go and
exempt. And he studies in the yeshiva.
He studies in the yeshiva. That is a huge problem. It's a huge problem, and it's simply not fair and not equal in a democracy.
Something.
In my opinion, who will protect me from that? If not the
I'll give you my answer.
Judges.
I'll give you my answer. First of all, it's a great privilege to serve in the Israeli Defense Forces.
Okay.
I look at the generation of my father, my mother. Well, my mother was already born in Israel, although not in the state of Israel. I was very fortunate. My father came from White Russia in 1920, a time of pogroms in White Russia. And he saw things that I never experienced. And to think, when I think of my great grandfather or great-grandfather, they would have said, wow, you're so lucky to live in the state. Also my parents, they would look at it as the greatest privilege we have to live in the state of Israel and serve the Israeli army.
But that's your value.
Maybe, yes. But I think that on the whole, most Israelis,
but here's one that doesn't want to serve.
Okay.
And he...
I didn't say that.
No, hypothetically, guys.
No,
let's
I
not...
want the choice.
Let's not
I just say I want the choice.
Here's one that doesn't want to serve. Let's pretend that he doesn't want to serve. For the sake of an argument.
No, I cannot do that.
Okay, for the sake of the argument.
But, so
Yossi down the street doesn't want to serve.
The fact is that when you live
But he's not a Haredi.
Yes, like the person who wanted to have his hair long, even though he's not a woman.
He's not a woman in the army. Never mind.
So, look, there is no right to equality in general. There is a right not to be discriminated against, and the idea, what is discrimination? That you treat similar people similarly or similar people differently. But if you treat different people similarly, that doesn't make it good. And the fact is that the Haredis are different in this respect, and we can live with this. The state can live. The most important thing is that they join the workforce at some point, and they do, most of them. It's not true anymore that most of them stay in the yeshiva forever. They come to a certain age.
But it is an example of how easily inequality, and this is life and death matter. People are sent to their death. And they go and make children, and this is an example, I think, rather than of how easily in this country parliament can make compromises that really hurt a huge part of the population.
I think,
and even kills them. One population is actually going to their death, and the other is not. So let's take this example for 1 second, and what do we do
Most people are not sent to their death. Most people, in fact, the army...
Depends.
The army has a great role also in creating the Israeli society as it is, because the mobility in Israeli society is fantastic. If you're born in one part of the country or in a certain... It doesn't matter. You can get wherever you wish to get most of the time. Of course, you can say also that right-wing people are discriminated against in other respects. Mm-hmm. Or maybe left-wing people feel That's one, by the way, this is one of the most interesting experiences, how many people feel discriminated against or as minorities or not as minorities and so on. And whichever way you cut it, yes, the Israeli society is very, very colorful. And the Jewish people always lived on disputes. But you don't need a court that aggravates the situation. And the fact is, I'm sorry to say, that the Israeli court aggravates the disputes among the different factions of society. It makes people feel like, I've been discriminated against. I didn't get my share. I didn't get my chance.
I think ultimately it's also a question of like what's more important, freedom or freedom and peace or equality. And I think that meaning it's equality for the sake of equality, I feel like is sometimes people just want to die on that hill. And ultimately it's not going to help anybody if the Haredim go. And secondly, democracy decided that, meaning a coalition was formed with those people. And I don't know how much you actually stand behind what you were saying or you were trying to challenge, but like ultimately a democratic process led to a coalition which passed that legislation. So that's democracy. That's us being represented
and
by
that's the main argument of the people who are opposing those reforms. They're saying, okay, in this democracy, like they decided to not draft the Haredis, they can decide. For example, that if you earn more than 40,000 shekels, you get 90% taxed. They can decide.
Well, by the way, I still remember times when people paid very, very high taxes. That was in my childhood. People paid skyrocketing taxes. Okay. And this was changed, thanks heaven, because the idea that you pay... then it started that people got payments that were not necessarily cash, but they got money for clothing and they got money for the car and they got money for all kinds of things that had nothing to do with their salary. The problem was that when they came to retire, all these benefits were taken away and you were left just with them. But no, I want to come back to your major point. You see, the coalitions in Israel also change. So you saw that the previous coalition, which didn't have the Haredi in it at all, didn't change this draft law also. And why didn't they do that? Because they also had inside a minority that part of which was the Muslim Brothers, and that was even more difficult maybe and more dangerous to the state than the Haredi.
Which is maybe why we need a third entity like the Supreme Court. Make it stronger.
Except that the Supreme Court didn't do anything during the whole period of the former government because they couldn't care less. Because the former government was a government they didn't want to destabilize. It is this government that the court wants to destabilize now. We didn't vote for the Supreme Court. I don't remember ever casting a vote for the Supreme Court, and the Supreme Court is behaving like a political party.
But maybe so what if, I'm just thinking out loud here.
Don't.
What if we change the committee, but we give them still the power? Why don't keep the power and if the committee is changed is decided by the politicians, it means our representatives, they choose the judges, let's say. In this scenario, why do we care about let's let them keep the power?
I don't understand. The justices?
He's saying make the Supreme Court more representative, more directly influenced by the vote.
Yes, but how can you make it without changing the
selection
committee?
I'm saying let's change
the election committee, but let's pass on the other
judicial review,
reforms. Let's let them. You know what I'm saying?
Of course, but the problem goes like this: at the moment you have 15 justices. In 2023, only 2 will be replaced.
So pack the court.
So that,
like in America. pack the courts.
There is no good reason for that. What you need to do really is, believe me, this is, I think, the major problem for most of those who oppose the reform. They don't want any change in the composition of the Supreme Court, and it doesn't really matter. Now, all the rest is part of that, but indeed, there is need for many more reforms. I mean, having another problem is that 60% of the time of the Supreme Court is consumed by these cases. So only 40% are left for civil law, criminal law, and tax law, etc., etc. Now, instead of choosing, and that would be the advantage of my initial proposal, to remove completely the possibility of judicial review of statutes and instead choose justices according to their speciality or expertise in the different fields of law. And then we will have, because one of our problems is that the civil law is so unclear that people keep running to court. Mm-hmm. And they have problems. There is no certainty in the Israeli legal system. And the Supreme Court is, in our system, the only one that writes precedents that are binding upon the other courts. And they don't do their job. So, because most of their time is consumed by these fantastic cases which draw a lot of public attention, but this isn't their major role. So that's what I would like to see, but this isn't going to happen because they went for a compromise. And the compromise means that they will be allowed, but they have to sit all together and decide. Yeah.
What about the fact that we don't have let's talk about the fact that Israel doesn't have a constitution. You're saying that basic laws shouldn't substitute a constitution. Is it possible for a state to exist? Is it sustainable for a state to exist without constitution? Isn't
England, New Zealand, they exist very well without the constitution. No constitution. Moreover, in Israel, when you try to settle to make a constitution, you create more havoc than the situation already, because indeed there are many disputes inside. Look, each family has Chagaidi, many families, let's say, have Chagaidi people and leftists, but in the family we manage all together. If we sat down to draft an agreement, we would be fighting all day. And that's a major problem. Now look at the Talmud. I mean, it's all disputes. So you don't have to necessarily solve all the disputes. A society can live very well with a large degree of disagreement. You don't have to fight over it.
I want to keep making life hard on you a little bit, because I'm thinking about the future. Okay,
yes.
I'm for the reform. I'm really for it. But I'm trying to look at the mindset of the opposers, and according to all statistics, in 30, 40, 50 years, Haredi and Orthodox and religious, there will be probably anything between 30 and 50% of the population, okay? Something like that. Let's say on the spectrum between Haredi and the religious, okay? And we can agree that their values, okay, some of their values are very different, or their core values are very different than me, Eitan's, I don't know about you. And they will have like in the committee, they will have almost an automatic majority in every elections. So what will happen in 30 or 40 years? Let's say the Haredis are 50%, okay, just for the sake of the argument. They are getting elected to the Knesset, and they decide to pass a law that you can't talk on the phone in Shabbat. They decide. They're the majority. So what do I do then? As a secular citizen.
It would be interesting to try to enforce this rule, but let's set this aside.
It's just an example.
But that's an example. Look, I don't know about your great-grandparents, but in my case, my great-grandparents were very, very Orthodox Jews.
Yeah.
And, Alterman, Nathan Alterman was one of our greatest poets. He used also to write columns. And one of them is about the parents who are so worried that the grandchild sees the grandfather, who is a very Orthodox Jew. And they're so worried about what kind of bad influence this little child will get from his grandfather. And he said, he says in his in this piece, where did you grow up? I mean, why are you so worried? My answer is, I'm not worried, but the future is not mine to see, and I'm really not worried about it. So many people in this country come from, even, the chief of staff and many others, they come from very religious homes. And you can see for yourself, I'm not really worried. And I'm sure also some of the Orthodox people are very liberal, by the way. Some of the other people who are not Orthodox at all, they're no less religious in their non-religion than the others. I mean, I don't see, if I look at the Israeli left, they're even more compelling than, or they are less liberal and less open to any suggestion than the Orthodox. The Orthodox usually don't care much about what you and I do. They care much more about themselves, their children, and so on, to the extent that it's possible. Of course, it isn't. It isn't completely. But I'm not worried, really.
Okay, but technically
everything is possible. What about the left party that wants to join forces with the Muslim Brothers? Is that okay for you? Can you accept that?
No.
Okay, so
I'll
this
appoint
is where
the
we are.
right-wing judge, and he will
but
something
it's not his job. The role of the judge is, as I said, it's to solve disputes in a peaceful manner under law. And if it so happens that the laws are made by a leftist government, they will look one way. If they're made by a right-wing party or a liberal party, they will look the other way around. I'm not so worried.
I am worried, unlike you, but I think that Naor is trying to solve. Naor is trying to solve a problem by plugging the wrong hole, basically.
Story of my life.
And it's I mean, in the end, what's leading to this population growth of the Haredim is the state of the welfare state, and that needs to be tackled, and not try to fix it by some kind of dictatorship.
It's interesting because if you look at Europe or at America, Europe is, in a way, because of the lack of children. I mean, in Israel, even the secular population is growing all the time. And if you look at Europe, it's almost a dying population. Yeah. And this, fortunately, is not our problem. That is a much more serious problem for the free world or the Western world with all its values and so on. But
the
Israel is different.
The Haredim and the Arabs are multiplying faster at a higher rate.
Not sure about the Arabs.
Depending if you look at the... there are different parts in them, but you're right. It's not all the same. And I don't know. There have been so many forecasts about what will happen in the world, and there will be too much population, and there won't be food, and there will be climate change, and God knows what, and so on. In the meanwhile, things are still, the world is still there.
And let's get, just before we finish this episode, let's get back to the reform itself, because first of all, you never finished the point of, you said what's the current situation with the committee, but you never explained what's the, which is important.
With the plan, of course.
And then maybe your criticism, what you would do differently.
So the plan is to have it 3 justices of the Supreme Court, 3 ministers, and 3 members of the Knesset, one of which will come from the opposition. In addition, one of each group should be a woman. Okay. And this is it now. In most of the Western world, judges are not at all on the committee that appoints the judges.
So why did they go with that?
Because some kind of a compromise. Again, I
But
mean,
333, you don't. Do they still require a majority of
5? No. The 7
simple
is
majority.
gone. It's a simple majority. 5 is also the quorum. So if only 5 show up, they can take the decisions.
Okay.
So
And
any coalition has an automatic majority.
Yes, that's true. How it will work, I believe. Look at the point. At this point in time, it is so unbalanced that you must have such a composition, because otherwise you get nowhere.
What will
And
happen?
I'm not worried.
But why are they even compromising? I mean, who is threatening to stop them? There's a coalition
Yeah.
who's passed the law.
Correct, but nonetheless, you see, they do take account of the public sentiment. And that makes sense, by the way, because they want to be reelected. They want to show the public that they care for everybody. And I told the members of the committee that apparently I have more trust in the politicians than some of them have in themselves.
But
because they
Yeah.
would like, one of our problems is that the way the judges are appointed now, they don't owe much to the public, and those who appoint them don't care about the public either. Now, the politicians are accountable. They are held accountable to the public. And if they appoint bad judges, this will come back to them. I mean, if the people go on seeing, because you get into the court nowadays, proceedings last forever. There is no certainty whatsoever. The procedure, both in civil law and in criminal law, is a disaster. It's a shame. It doesn't stand up to any norms acceptable in Western democracies. We need to fix all of these. But the first step, and this is really the reform now, it's the first step. Number one, the composition of the appointments committee. Number two, that the basic laws cannot be anymore reviewed by the judiciary. And then now we started debating in the committee also the judicial review of statutes, because one of the things the court does when it reviews, it says, this is unreasonable. Anything is unreasonable. Now, unreasonable in common law countries, let's say in England, it has to be so unreasonable, the act, that no reasonable authority would have done this. Or in America, the definition is vexatious and arbitrary. In Israel, it's just in the eyes of the beholder. So let's say even the appointment of Deri, which was a government act, of course, they said, well, yeah, it was legal. There's no doubt about that. And there were good reasons for Netanyahu to appoint Deri, because he was the head of the second largest party in the coalition. But nonetheless, in our opinion, it was extremely unreasonable to appoint him. Now, this is completely arbitrary. The judges, in a way, are deciding these matters unreasonably. This is unreasonable. The fact is that 5 justices thought that maybe it was reasonable, but for different reasons. Now, this cannot be. I mean, so we have to fix this matter of reasonable has to be defined properly as vexatious and arbitrary, or as so unreasonable as in England that no authority, let's say painting the whole streets with red and white, not leaving one place for parking, that would be extremely unreasonable, but not what we have. So this is the very basis of the reform. If we can't pass these things, then it doesn't help, because the Knesset has already tried to amend its law several times. It was sent by the court to amend sometimes.
And what will happen
and they
this
said,
time if the court says those laws are illegal?
Then we have I want to believe that the court will not go to such an extreme. I find this goes beyond even my imagination, I have to say.
It's like what happened before the Big Bang.
Yeah. I agree.
Yeah. That's scary.
Okay.
That's scary. Because they have nothing to lose. What do they have to lose, really? Why not die on that hill?
Only everything.
I think
but only everything if they don't. They only have everything to lose if they don't oppose it.
I don't think so. I think that the public sees the problems for what they are. The fact is, they say that the public had no idea when they made the vote that they will have a reform. But wait, in the Likud there were primaries. And Yariv Levin came up, the Minister of Justice came up number 1 in the primaries. Now...
And everybody knew his agenda.
Exactly.
Yes.
I mean, and not only that, he would never have been elected as the great person of security, as the fighter against Iran. I mean, the reason he came out number 1 was because the reform of the legal system was top on the agenda of everybody who voted right-wing. We wanted to see a reform. Mm-hmm. And the same is true for the Zionist Religious Party. The same is true also for the Haredi. All this group, the 64 members, wanted a reform.
Yeah. And what will you do if, last question, if there's a very big compromise, like the president's compromise, and, a compromise which leaves the right, in essence, with nothing?
I don't think this is going to happen this time. I don't expect this to happen. Mm-hmm. You may agree, let's say, that not unanimous 15, but 80%, and then an override clause. Again, the override must not be more than 61. It's pretty difficult to get to 61. But the answer of the dead to the blind, we shall live and see. I believe, okay. I'm very optimistic. I believe in the reform. I think it will be very good for all citizens. And moreover, I'm confident that any government that will be formed later on will not abandon this reform. By the way, they didn't even stipulate that to go back on the reform, you need 61. Any simple majority can abolish the reform. I'm confident that no coalition will abolish the reform.
From your words to
God.
Aaron Barak. But
that's your equivalent of God.
No, God forbid. Thank you.
Thank you so much. Thanks for the work you're doing for the committee, and it's really, really inspiring. I feel like you do it,
directly, definitely.
Yeah, from the heart. Just from the heart. Pure Zionism.
Yes.
So thank you so much for coming, Professor Talia Einhorn.
Thank you so much for having me.
Thank you.
Wonderful.
Hope you guys enjoyed. See you next time.